Good morning, everyone. Thanks for coming to this first session of LawCon. The first thing I'll do is talk about the so-called standard entity types. Sometimes these are called for-profit businesses. That's a bit of a misnomer, but generally speaking, these are the kinds of entities you would form if you want to start a business and make money and pay taxes and all of that sort of thing. Then I'll shift over to briefly talk about nonprofit business entity types. And then at the end, I'll finish up by talking about hybrid entity types, the B Corps and things like that, that exist both to make money and serve some public good. Okay, so let's start off with partnerships. So what's a partnership actually, right? Well, it turns out there's a legal definition for it. It's an association of two or more persons to carry on as co-owners of a business for profit. And so that's perhaps fairly intuitive, but the definition is more interesting for what it doesn't say. So the first question you might have is, do you need an agreement um, to enter into a partnership? And the answer is kind of a tricky yes. You do need an agreement. The Uniform Partnership Act, Section 6, um, does tell us that an association, or the comments do tell us that an association of two or more implies an agreement. But notice that the statute doesn't say that a writing is necessary. So you only have to carry on as co-owners of a business for profit. You don't have to agree in writing to do so. And you don't have to intend to enter into a partnership. You only have to intend to carry on as co-owners of a business for profit. So generally speaking, nowadays, with the advent of LLCs, which, by the way, were invented here in Wyoming in 1977, which we'll talk about a little bit more later, the question nowadays becomes whether we can imply an agreement to be partners from the conduct of two people. So, for example, Tom Sawyer's painting the fence here, he's whitewashing the fence. Huck Finn comes along and picks up a brush and starts painting too. Do we have a partnership? Probably not, right? There's no express agreement to act as partners. So to establish a partnership, you'd have to argue about something about implying an agreement, right? Now, though, let's say Tom says to Huck, Huck, I'll split my pay with you, and Huck starts painting the fence too. Do we have a partnership? It looks like it in this case, right? Because we have an agreement. Although Huck didn't explicitly say we have an agreement, his actions imply that he agrees with Tom Sawyer's offer to enter into a partnership, right? Okay, so that's the danger nowadays, right? Is finding yourself in a partnership entirely by accident. And the reason that's a problem is that if that partnership is hit with tort liabilities or contract liabilities or whatever kind of liabilities, the partnership itself is liable. But if there isn't enough money here at the partnership level to pay those debts, the two partners themselves are liable, right? Um, and that's difficult, right? Um, According to the Uniform Partnership Act, partners are personally liable for the obligations of the partnership. Again, tort, contract, breaches of fiduciary duty, really any cause of action. Um, uh, and the newer version of the Uniform Partnership Act tells us more explicitly, except as otherwise provided in these subsections, which really don't say much. All partners are jointly and severally liable for all obligations of the partnership unless otherwise specified by one. Some of the exceptions are if some of these liabilities arose before someone was admitted as a partner, then there's no partnership and so on. And the reason this is a problem is that pretty much anything that's not protected by statute is on the line. So your house, your car, your wine collection, whatever, right? Retirement accounts may have some protection. The bankruptcy code allows states to give some protection for, some portion of your home and so on. But everything else is available to a partnership credit. So that poses somewhat of a danger, right, to to members of a partnership or to partners in a partnership. Okay. Um, so one way to get around some of that is via a limited partnership. So what's the difference between a limited partnership and a general partnership? Well, a limited partnership provides limited liability for its limited partners. Now, that liability um, is limited to passive investors. So, um, as long as these limited partners don't get involved in the management of the business, they are protected. So they are not, their assets and liabilities and so on are not open. Their personal assets rather and property are not open to um, being taken by a contract court, whatever kind of credit. Um, the general partner, however, is still open to that kind of liability. So the general partner's house, car, wine collection, all of that sort of stuff. If a limited partner starts to get involved in running the business, the limited partner is treated as a general partner by law. And there are some cases where that has in fact happened, and it's been a disastrous mistake for the limited partner. So, how can we limit the liability of the general partner, or of this individual, I should say, who is managing the limited partnership? Well, you can make the limited partner a corporation, a limited liability company, right? And then have the individual sitting up here as the sole shareholder or the sole member of the corporation or the limited liability company. Now, you might be thinking, what if that's not an option, right? Some states, for example, require that law firms be some sort of partnership without an entity here that's got the liability shield. And the answer is insurance, right? You can get insurance for the general partner here, malpractice insurance typically, if you're an attorney, but other kinds of insurance, malpractice insurance, if you're a doctor or what have you, right? And of course, insurance typically has limits, but hopefully you can set the limits high enough that it provides adequate protection for the individual running the limited partnership here. So already you can see that the law, which started out somewhere here with partnerships, right, just two people going into business, is looking for ways to create liability protection, right, for people that go into business. So the next step that the law tended to recognize in this area were limited liability partnerships. So we went from partnerships to limited partnerships or LPs to limited liability partnerships or LLPs. In LLPs, partners are not liable for the debts and obligations of the business, except to the extent that they've agreed to be or bear personal fault, right? Contract claims, yes, all of them, right? Including those agreed to by other partners on behalf of the LLP. Tort claims, they're only liable for those where they bear personal fault, right? So only personal fault is excluded from the liability shield. And then just to build on the partnership theme even more, a limited liability limited partnership is a limited partnership where the general partner has the liability shield that's provided by a limited liability partnership. So you can see that the law has been searching for a way to create as much liability protection in the partnership area as possible. Especially in those jurisdictions or in those states where certain kinds of businesses have to be partnerships. Now, some states, Illinois, Wyoming, for example, allow entities like law firms to be limited liability companies, and that gives some good protection. The statutes about lawyers and the professional responsibility statute still puts some liability onto lawyers, and that's where malpractice insurance comes in. Okay, so that's partnerships. Those are partnerships in a nutshell. If you're, here at LawCon and you're thinking, you want to start a blockchain business, for example, right? To track whatever through the supply chain, let's say, and you want to know what kind of business entity to start, you're thinking at this point that it should not be a partnership. And you're absolutely correct. You should not create a partnership for any type of business where the law allows you to create some other kind of entity form. Partnerships are on the extreme. They're pretty much outdated nowadays. Let's jump to the other end and let's talk about corporations, right? If you look at all of the entity types that are out there, this is these numbers are a little bit dated, and they look at things from the perspective of the Internal Revenue Service, which doesn't really recognize LLCs as a separate entity form. Most businesses are proprietorships, sole proprietorships. An individual starts the business, has an idea, realizes that he or she can do something pretty well. It starts to do it, starts making money on it, and files taxes with a Schedule C, a business, and, makes money that way. Basically, simplifying somewhat, a proprietorship is a one-person partnership. All right. The next most common type of business is the partnership, which we just discussed, and the least most common type is the corporation. So this is by numbers, the numbers of entities. But if you look at the receipts that they have, right, the income that the businesses make, it's the reverse, right? Most money is made by corporations. Corporations are very important. It's the sort of the second most, the second oldest type of business entity. Kind of not thinking about oddball things like joint stock companies that are kind of between partnership and corporations. Most business is done by corporations, including by the Fortune 500 and so on. Venture capital investors tend to like to invest in corporations and other types of investors. And you need to be basically, with some oddball exceptions, you need to be a corporation to go public and be listed on the stock exchange. So it's not surprising that most revenue is made by corporations. Then partnerships are next, and then sole proprietorships. So what kind of corporations are out there? Let's talk about corporations. And as kind of a preview, we've talked about partnerships, we're going to talk about corporations. The reason is that we'll talk about LLCs last. LLCs are in the middle of those two. They combine attributes of both partnerships and corporations. So there's the realm of the public corporation, publicly held, Microsoft, IBM, Apple, General Motors, whatever. They're characterized by a large secondary market in which you can buy and sell shares. If you don't like being an owner of Microsoft anymore, you log into your Fidelity account, you click sell, and you're no longer an owner of Microsoft, right? You no longer have any rights to Microsoft's profits, shares, whatever. Right? Voting rights, whatever. Then there are closed corporations, and for most people participating in LawCon, if you create a corporation because that's what your investors demand you'll be a closed corporation. There's no secondary market for its stock. You can't just go out and sell it on, the New York Stock Exchange and your Fidelity account. You can't just sell your shares if you don't like being an owner of the company anymore. There's typically a small number of shareholders, and they're all actively involved in running the firm. And they look a lot like partnerships. Okay. So what are some basic attributes of corporations? They have a legal personality, limited liability, separation of ownership and control, flexible capital, liquidity. They tend to be more liquid than other forms, and they have a flexible capital structure. And let's go through each of these and see what that means. Now let's start with a legal personality. A corporation is an entity with a nearly complete separate existence from its owners. So you can think of it as a legal fiction, right? It's said that corporations possess some constitutional rights. That's not entirely correct. It's only true to the extent that they possess constitutional rights to the extent that their shareholders have constitutional rights. So, if the Laramie Boomerang brings a First Amendment claim on the ground that, the state of Wyoming is trying to censor what it's saying, it's bringing that claim on the ground that its owners and to a lesser extent its employees have a right to say the things that it wants to print, right? So it's really the corporation, to the extent that it possesses constitutional rights, is a placeholder for the rights of its owners. It's also a separate taxpayer. So the corporation, as long as it's a C corporation, which again you may very well be if you're looking for investors, is a separate taxpayer. It pays taxes, and then if it pays dividends, the shareholders pay taxes on those dividends. The exception to that is the S corporation, where the revenue of the corporation passes through to its owners. And again, that looks more like a partnership. Okay, limited liability. Perhaps most important, the corporation, unlike a partnership, provides limited liability to its owners. So if a liability hits the company, a contract claim or a tort claim or whatever, that liability is the responsibility of the corporation. But if the corporation runs out of money, you cannot go up to the owners and collect from them. So note, these guys have smiles on their faces, whereas the stick partners did not. And this is a very large benefit, very big, very important benefit of being a corporation, right? You're not liable. You can never be liable unless the corporate veil is pierced, and that only happens in very unusual circumstances if there's some wrongdoing here. If there's a lack of separateness between the owners and the corporation, or if the corporation is used for some nefarious purposes, you can never lose more than you invest in the company, right? One great thing about this is it allows for the easy separation of owners and control. Owners of a business don't want to allow others to manage their business if those managers' actions can result in their wine collections, their houses, their cars being taken away. But we want owners to allow others to manage their business if, for example, they can do it more efficiently, right? And that's what the separation of ownership and control is really all about, right? It's risky to allow other people to manage your partnership, because if they do something wrong, then you're going to be on the hook, right? That's not the case in a corporation. Under the Delaware statute and the Model Business Corporation Act, Wyoming's a Model Business Corporation Act state, the board of directors runs a corporation, not the shareholders. The shareholders have some limited voting rights to select the board of directors. Generally speaking, you can say that a board of directors acts and shareholders can only react to what they do. They can react by voting out the board of directors and things like that, and so on. Right? Corporations tend to be more liquid than. There we are. Rule of thumb: boards act and shareholders react. Shareholders can vote. They can elect the directors. They can vote on amending the articles of incorporation. They can vote on the bylaws, right? The rules under which the corporation has to operate. They can vote on things that are called fundamental transactions, mergers, acquisitions, that kind of thing, and some odds and ends like approving auditors, right? The Dodd-Frank Act provides shareholders every third year with an advisory vote on executive compensation. So the vote is only advisory. It doesn't bind the board of directors. Okay. We've seen this already. The board of directors runs the corporation. And so the question is that a boon or a bane, right? it creates a situation, Berlin means in their famous 1932 book, it creates a situation where the people that run the business do not have the ultimate responsibility for the profit and loss of the business, right? So there's the sense out there that the managers can abuse the business that's left to their charge and run it to their benefit rather than the benefit of the shareholders, rather than to the benefit of the owners who put the money into the business. Okay, um, and corporate law, generally speaking, the fundamental corporate law problem, and we won't get into this too much today, but beware of it. All of corporate law is making sure that shareholders get the benefit of their bargains with their managers and with the firms. And you can kind of broaden that a little bit and think of the corporation as a nexus of contracts. It's kind of a famous term that's out there, right? Um, so uh, all of these people, the shareholders, the managers they hire to run the company, the employees, right? Creditors who they borrow money from, communities, all of them kind of come together at the firm. You can think of the firm as a focal point. And a focal point is an economics term for this place, could be a non-material place, right? It could be kind of an imaginary place where individuals naturally tend to come together to interact with each other, right? So people tend to come together at the corporation to do business, right? To buy, sell, produce, etc. Um, all of these contracts come together at the firm. And we've been saying this in the sense of the corporation, but really this is true of all of the entity types that we see today, that we're going to talk about today. Okay, so corporate law is enabling, but Easterbrook and Fischel in a famous book said, it should be enabling, and so why, right? And the idea is that not all contracts are bargained for, but they are all priced. So all of these contracts here are priced into the share price and really the price of the products of the corporation as well. Share prices, relatively speaking, reflect well the public information about a firm and therefore its true value and how well it does. And firms that aren't able to offer investors a good deal are eventually going to fail, right? And so there's a sense that the major features of the corporate form that seem to be the result of exploitation, let's say, for lack of a better term, are actually the result of contract, right? So we don't need to regulate these things because the firm is a consensual arrangement. And as long as we're in a liquid market, and this is why this is especially relevant in the corporation area, these things are going to be priced in. And so it's only when you can identify kind of a market failure or an area in which the corporate form maybe doesn't work best, do you have a case for regulation or going some other way, right? Now, most people agree on that point. They disagree on how often that's the case, right? So when might that be the case, right? When does it make sense to impose rules upon the parties, right? In these sort of standard form contracts that comprise the different entity types. If you have information asymmetries, for example, right? Latecomer terms, if people join the firm later. These are the types of situations, and I mention all this because it's especially relevant to close corporations that some of you might form. In these situations, you want to be careful. The corporate law will tend to protect you, but you want to be especially careful that you protect yourself via contract, right? Because the law is, even though in theory it protects you, it's reluctant to do so, right? So you want to make sure that if you're in a situation where you can't just follow the Wall Street rule, right, and sell your shares if you don't like it, especially because your business is your baby, right? You want to make sure you protect yourself by contract. And that's where hiring a good attorney comes in. Again, corporations are liquid. That's especially the case for public corporations. where you can just get out onto Fidelity and sell your shares. In a small business, like many of the folks participating in LawCon will have, again, you want to protect yourself with agreements, right? Make sure that you have agreements with your fellow shareholders, with your investors, um, and so on to protect yourself, right? You don't want to be stuck with um, someone running your business into the ground and you're stuck not being able to get out. Um, Corporations also have the benefit of having a flexible capital structure. LLCs are even more flexible in this regard. Um, Generally speaking, for everyone here at LawCon today, think of this as being debt and equity, right? Debt is money you borrow from a bank. It has to be repaid. Equity is um, an ownership share in the business, right? Um, okay, so those are corporations in a nutshell. Now let's get to LLCs, which is probably going to be quite important to everyone here today. So LLCs have become more and more important, and the number today is probably somewhere here or off the charts. Okay, so they've become very important. Again, they were introduced here in Wyoming as a way to conveniently break up the ownership rights in mineral leases and things like that, right? Who owns the surface rights? Who owns the gas rights? Who owns the oil rights? Who owns the air rights, right? Um, the benefit of an LLC is that you can split up the ownership rights, the control rights, the profit rights, the loss rights by contract. You just spell it in. You just say what it is, and that's the rule for the people involved in the company. You can do that as well with partnerships, but there you've got the liability concerns. You can also do it with corporations, but it gets very complicated to do it within the restrictions of the corporate form that require you to have shares, right? And how you split all that. So the LLC exploded in the 80s and 90s. In 1988, the IRS said LLCs could qualify for partnership-like tax treatment. In 1997, it made it very easy. You just had to check a box and bam, you got pass-through tax treatment. The great thing about that is that you no longer were subject to double taxation, but that's the benefit of the partnership, but you had the full limited liability protection of the corporation, right? And so there we are, right? Tax benefits of partnerships, you're only taxed once on the income that the business makes. So it's not taxed at the business level. And then when dividends are paid at the shareholder level, it's just taxed once. It flows through to the owners, right? But you've got full limited liability. And you don't have any of the restrictions applicable to S corporations, right? Like the number of shareholders, the maximum revenue, and all that sort of stuff. Um, Now, one, other kind, because I'm trying to be as comprehensive as possible and give you a sense of all the entity types that are out there, in case there are any engineers out there, right? Anyone who's part of the professions, engineers, doctors, lawyers, what have you. There do exist professional corporations, PCs, and professional LLCs, PLLCs. Those look like corporations and LLCs, with the one caveat that only members of the profession specified can be a shareholder or a member, in other words, an owner of the business, right? And what that does is it makes sure that the incentives of all the owners are aligned, at least along that one dimension, right? So if it's an engineering firm, you don't suddenly have, an environmentalist buying a bunch of shares in the firm and trying to influence the direction of the company. If it has to be an engineer who owns the firm, right? Okay. So how do you form these entities? Well, the common denominator between all of the entity types receiving limited liability is filing. So I won't click on the links here for the sake of our presentation, but this is a live link that you can click on later if this presentation is made available. You would file the articles of organization for an LLC in the designated state office, um, in this case, the Wyoming Secretary of State. There are some required and optional contents set forth in the Uniform Limited Liability Company Act. Typically, um, things like the name of the LLC, the address of the registered agent. That's where the registered agent, or the address for the service of process, is where official communications are sent, right? The yearly franchise tax bill, for example, from the state. If someone sues the entity, that's where service of process is made, and so on. The filing fees and minimum franchise taxes vary. In Wyoming, it costs $100 to make an LLC, and it costs an extra $2 to do that online. If you do it online, you can quite literally have an LLC within a few minutes. You get online, you fill out all the information, including who will be the registered agent, again, where official communications relating to the entity are sent. You pay $102 with your credit card, and you have a business, right? Immediately, you are given a downloadable copy of the articles of organization for your business. You do all of that on the Secretary of State's website, right? Um, Other formation tasks include picking a name for the LLC. It's very important. You have to have, as part of the name, the letters LLC, Limited Liability Company, L.C. Something like that. The point of that is that so people who are doing business with you know that the business with whom they are doing business has limited liability protection. That's how they know that if they want to sue the business, they cannot go after your personal assets, but only the assets of the business. So it's very important always to include that LLC on your business cards, letterhead, anywhere that you put the name of the company, so that people doing business with you know that your personal assets are not on the line, not available to them in a lawsuit. Um, we talked about the registered agent. It's always a great idea. A lawyer should always recommend that a limited liability company have an operating agreement. It discusses the rights and duties of the members vis-a-vis each other, which is very important if there's more than one member, right? Who has control? What are the rights to the profits, and so on. It's also important for single member LLCs because you want to show that you are separate from your LLC, right? You want to show that the LLC is a separate entity with its own rules, and that you are not that LLC. You are the owner of the LLC. You might run the LLC, but that is separate from you. And that's part of ensuring that you have that limited liability protection. So for that reason, a good lawyer will always draft an operating agreement for you. So what are the default rules? These are the default rules for sharing profits, losses, control, all of that in an LLC. These are laid out by statute. You can change all of these, right? So absent contrary agreement, profits and losses are allocated pro rata by member. So if you have two members, one contributes 90% of the money to the LLC, one donates 10% of the starting capital of the LLC. You still share profits and losses equally. If the company makes $1,000, each of you is entitled to 500 of that. That might be unintuitive, but that's the rule. Again, you can vary this by contract, no problem, right? But just be aware that this is the standard rule, and that's the rule for partnerships as well. When losses are allocated to your capital account, let's say someone put in $9,000, someone put in $1,000. If there's $1,000 loss, again, absent contrary agreement, the one individual's capital account is now $8,500, and the others is $500. And that's what they're entitled to if the business liquidates and they take their money out. You can withdraw and demand payment of your interest upon giving notice that the statute requires. Again, you can contract around this. You can make it so that withdrawal is not allowed. You can assign your interest to somebody else. Again, unless the LLC says otherwise. Your interest, the term interest, applies to your financial rights. It does not apply to control rights. So let's talk about control rights. Absent contrary agreement, each member has equal rights to run the LLC, even if one put in more money than the other. Most everyday matters are decided by a majority vote of the members. But big things, mergers, acquisition, dissolution, letting in a new member requires unanimous consent because the LLC is a contract among the members. And to alter a contract, everyone has to agree to the alteration. Again, that rule also can be contracted around. So you can have like a managing member who runs the business and can make all decisions. Okay. Manager-managed LLCs can be structured like a corporation to look more like a corporation where there's a board of directors. It's not the owners, it's not the members who are running it, but separate managers, right? The default is that members, the owners, the equivalent of the partners run the business, but you can specify it so that a separate board or set of managers runs the business. Okay. So that's a lot of information. Let's see how those things play out here. Before I get started, you should think of everything I just told you as kind of an off-the-rack solution, right, for your business or for your client's business. All of those things can be altered and modified, but it makes sense for your business or for your client's business to start with the off-the-rack solution that most closely fits that business and then modify it around the edges as you need it. It's kind of like buying a suit in the store. You buy one that's, about your size, whatever your size is, right? And then you modify the length of the sleeves, you modify the seam on the back and so on, right, to fit you. And then you've got exactly what you need. So here's a summary. Partnerships, LLCs, and corporations. Profits are taxed once. That's a good thing. In LLCs, it's the same, assuming you check the box, and everyone does. In corporations, if it's a C Corp, profits are taxed twice. That's a disadvantage of corporations. Right? Losses flow through to the owners in partnerships and LLCs. Here, again, if the box is checked. Losses stay in the firm and can be carried forward for a limited time, but not forever. You can accumulate profits in an LLC or partnership. Because there's single taxation, the IRS doesn't care, right? With corporations, the IRS doesn't want you to accumulate profits in the firm. It wants you to pay them out so that it can tax them. So if excess money hangs around in the corporation for too long, the IRS will go after it. Partners run partnerships typically. The board of directors runs corporations. And LLCs, it can be either way. You can pick the one that you want, right? With a partnership, there's no filing required with the state unless you want one of the limited liability versions of it. You just start doing business, right? Like Huck and Tom. With LLCs and corporations, you have to file with the state and in effect pay the state a fee for the benefits that you get for having an LLC or corporation, the limited liability and so on, right? You should always have a partnership agreement or an operating agreement, right? Good advice. Always ask your attorney for one or always tell your clients why they should have one. Corporations can have bylaws and shareholder agreements, but they often don't, right? The off-the-rack solution for a corporation, once you're in that form, is often good enough. The interesting thing here on the last line is you can have single member LLCs. You need 2 or more people for a partnership. You can have single shareholder corporations as well. This link here takes you to the Wyoming Secretary of State website, and it gives you some more information about the various entity types and their advantages and so on. Okay, so small businesses tend to be partnerships or nowadays LLCs, or sometimes S corporations if there's some special reason to do it. Right? The owners are typically the decision makers here. decision making tends to be pretty informal and consensus-like, right? Um, uh, it usually looks like a consensus model, right? It's less common to have an official vote than it is in a corporation, right? In a public corporation, you can't have a consensus decision-making model, right? The shareholders have to vote, at least on the things to which shareholders are entitled. Medium-sized businesses tend to be LLCs or C corporations. It becomes harder and harder to have a consensus-like decision-making model. There are simply too many people involved in the business for everyone to be able to get together in a room or on a Zoom conference call or a Zoom meeting, kind of hash out what they want to do and then decide to do it. You can, in a partnership, have centralized management. You can have that in an LLC as well, or have a manager-managed LLC. Corporate law necessarily is not a consensus-like model. It's a centralized power model where the board of directors makes the decisions. But you can weaken that some, move back to toward a consensus-like model with shareholder agreements, where shareholders agree amongst themselves how they vote. Okay. In public corporations, C corps are the norm. Maybe limited liability companies. Certainly for holding companies, that might make sense. Consensus is impossible, right? Imagine getting together in a room with all the shareholders of Microsoft to make a decision, right? And so for that reason, decision making is authority-based. The board of directors makes the decisions, and if the shareholders don't like it, they can vote out the board. The formation process, we've talked about that some already. You might use a service and draft the things that we talked about. Nowadays, in the last, I'd say 3 years, 5 years maybe, it's easy to do this sort of thing on your own and not even use an incorporation service, right? And so the question is where to incorporate. A state is not allowed to exclude foreign corporations, um, uh, but it can, charge a foreign business to do business in the state. So if you're going to do a substantial amount of business in a state, you probably want to either incorporate there or file as a foreign entity doing business in that state. So I have some slides here on partnership capital, and this applies to LLCs as well. And for the interest of time, I'm going to just kind of go through these slides more quickly, but it illustrates what I talked about uh, uh, in talking about how profits and losses are allocated. Okay, so Alice puts in 10,000, Bob puts in 1,000. If the company makes $2,000 the first year, that 2,000 gets split evenly among Alice and Bob. So this is how much their capital account balance is at the end of the year. And notice it's pro rata by partner, not by contribution amount. The same thing is true of losses, right? Losses are split evenly. Okay. Profits, again, are split evenly. If they take money out of the business, they get an equal share, right? Now, you can contract around all of this, right? It's not a problem to contract around all of this, right? Here are some rules about how losses follow profits. And again, no problem. If you want to divide profits one way, losses the other way, not a problem, right? Here's an example that you can look at on your own that talks about truly the difficulties and the problems with partnerships. Note that in this situation, these partners wind up having to pay something into the business. And all of this about partnership capital applies to LLCs as well, except they can't be forced to pay something into the business. That's kind of the biggest difference. But I want to take just the last 15 minutes or so, 18 minutes, and talk about nonprofit entities and then the hybrids. Note that on this chart here, we've got nonprofits, tax-exempt organizations, charitable organizations, and foundations, right? Note that nonprofits are the broadest of these four categories, and they include all of the other terms. And each one of these is a subgroup as we move inward of the other. Um, and as we move inside the oval here, um, the rules governing them get tighter. So nonprofits do make money. The difference is that the money they make isn't called profit, but, quote, an excess of revenues over expenses. And it's not distributed to the owners, right? In fact, there isn't really such a thing as an ownership interest. Nonprofit, typically corporations, but we'll look at the different types of nonprofit entities, have members or something like that, right? The point is that the money that they make is retained within the enterprise to further the interests of the enterprise. A tax-exempt organization is a type of nonprofit not subject to federal income tax, right? To be tax-exempt, you have to apply for an exemption to the IRS. Section 501C of the Internal Revenue Code allows about 30 types of exempt entities, the most common of which is the 501c3. These organizations don't pay tax on their quote-unquote exempt function income, but they do pay tax on unrelated business income. Charitable organizations are, again, a subset of this. The big difference there is they can accept tax-deductible gifts. Most charitable organizations, with a few exceptions around the edges, are 501c3 organizations. The great benefit of these is that the people who give them money can deduct the money from their taxes. The cost is that they're almost completely barred from any kind of political activity. And private foundations are in the middle here. Private foundations are susceptible to control by a small group of donors. And for that reason, they have special statutory control, right? There's a presumption that a 501c3 organization is a private foundation. And to get out of this private foundation category, you have to either be kind of an accepted form of charity, a church, hospital, university, whatever, have an active fundraising program that gets contributions from multiple sources, or kind of be tied to one of those previous two kinds of entities. The idea here is that the IRS and society in general doesn't want a small group of owners creating a so-called charity that they kind of run for their own personal interests. If you are a private foundation, there are different kinds of taxes and other regulations to which you're subject. There we are. So those are the four types. So let's look at the entity types for nonprofits. So there can be an unincorporated association, basically like a partnership, right? Or perhaps an LLC, just a group of people who get together for a common purpose. The Unincorporated Nonprofit Business Association Act, in theory, gives some limited liability protection for the people who get together doing this, but be careful, right? There's still a lot more liability risks here than if you actually have a real entity giving you, an entity that you pay for to get limited liability protection. You can get 501c3 status here. That's important to remember, but remember, typically you don't want to be in one of these forms if you can avoid it, right? The next form is the charitable trust. Here, a trustee holds the assets in trust to the assets of the entity for the donor's public charitable purposes. This is pretty good, right? The donors are not liable to third parties for tort, contract, whatever liabilities. They can get 501c3 status. It is possible. And what's nice about these is you get more privacy than with a nonprofit corporation because you don't file anything with the state, right? You just create it with a bunch of legal documents. So these are already pretty nice. But by far the most common is the nonprofit corporation. Or nowadays, nonprofit LLCs are becoming more and more common, right? It's a nonprofit corporation. Again, it has members, not shareholders, right? There's isn't really anyone to distribute the money to, even. And that's where we get the so-called non-distribution constraint. You get the typical corporate benefits, uh, separation of ownership and control, limited liabilities, separate personhood and all of that. But you have to follow the formalities, including limiting the purposes of the entity to those eligible for 501c3 status. Make sure you also follow your state's requirements um, for nonprofit status. In addition to what's required at the federal level, states often have their own requirements on what you have to do or the kinds of activities you can engage in to get nonprofit status with the states. So that's the important point there. Okay, so those are for-profit entities, probably the most important for all of you. Nonprofits, because sometimes there are good reasons to do a nonprofit, right? You might want to do some good for the world. Here, I'm going to talk about the hybrid entity types, right? And I'd like to thank a colleague for providing kind of the basis for this material. Professor Murray is one of the foremost authorities on this topic. So think about an entity that's a hybrid of the two, right? That does engage in commercial activity to get revenue and it pays taxes and all of that stuff. But it also directly looks at social good, right? So the primary good, a common good is the primary purpose here, right? And so the important part here is common good. Most of these entity types have to sort of do general good for the world as a whole. And we'll look at that concept in more detail and also some of the difficulties that come out of that, okay? The point here is that most of these entities don't allow for a very specific public good, right? Here are the different forms. The benefit corporation or public benefit corporation is easily the most common, right? Wyoming will soon have, if it doesn't already have, a benefit corporation statute that allows you to create a benefit corporation that has this hybrid purpose. The low profit limited liability company is another one. The benefit limited liability company is a third type, kind of looks more like the benefit corporation. Again, keeping in mind the differences between corporations and LLCs. And the special purpose corporation, which actually lets you get specific in the good that you're trying to create. One important thing to note here is the difference between a legal entity form and certification. All of these things are provided for by statute, and to create one of these entities, you have to make a filing with the state in the way that we discussed, okay? There's an entity out there called B Labs, which will actually give a certification to some of these other entities, okay? Let's say that they meet certain long list of criteria where they're serving the public good. Up until recently, you didn't have to be a benefit corporation, for example, to get this certification from B Lab. One thing B Lab recently did is say that if your state has a benefit corporation statute, then you had to become that type of entity. You had to change your entity form over to a benefit corporation to get this certification by B Lab. And a lot of companies didn't do that. And this will get into, we'll kind of look at why in a minute. But Etsy, the company in Delaware, which actually had B Lab certification, did not convert to a benefit corporation form after Delaware enacted a benefit corporation statute, even though Delaware modified its benefit corporation statute to make it easier for companies like Etsy to convert to a B Corp. And, so why is that? Why is that? So this sort of busy slide, I hope, explains, right? So benefit corporations must have a general public purpose out there, right? So everything that a benefit corporation does is by statute compared to some third-party standard. It's typically a private third-party standard, right? So you create this corporation for the public good, but you're only meeting the requirements of the statute if some third private party says that you are. And if you're thinking that's problematic, why should some third party, determine whether I'm serving the public good or not? You're not alone, right? Same is true of limited liability companies. It's not true of L3Cs and special purpose corporations, right? So the danger here, one danger, is that your personal, private, charitable desires with creating one of these entities can kind of be hijacked by a third party, right? And you don't want that. You don't want to be subject to that. And the statutes are written very broadly. They say general public good, including the environment, communities, etc., right? So does that mean that a community, right, can actually sue you, or an environmental group can sue you if you're not doing enough for the environment or community? The statutes are worded so problematically, and Professor Murray and I've written about these as well. Anyone who wants to contact me later can feel free. Are so problematic that it's actually quite risky to create one of these entity types, right? And so I have these, suppliers, shareholders, customers, suppliers, communities, employees. Can any of these entities sue you, right, if you don't do enough for them? Even worse, what if your board of directors, right, or board of managers does something that you don't like? Can you as a shareholder now sue them to recover the way you can in a corporation? Or can they just say, well, look, I was serving the interests of this supplier or this customer or these employees, right? And escape liability for that, when in other words, can they mask their self-serving behavior by saying, well, really, we were just serving one of these constituencies, right? So that's why Etsy didn't change over. Well, that, and one other reason, which is there's very little case law out there on these entities. So that's the second risk, right? Delaware has excellent case law, for example, on corporate law, right? So does Wyoming and many other states. There's very little case law out there on these entity types, right? A benefit corporation, say in the case of Delaware and Wyoming, or an L3C or what have you. And so it's very risky for a large successful business like Etsy to switch over to one of these entity types, okay? It's much safer for Etsy, for example, to stay a normal corporation, a quote unquote for-profit corporation, pay taxes on the money that it makes, and just contribute, right? Just contribute to the causes that it wants to, right, out of the corporate treasury, the way it could, up until now, the way it always was able to. So until some of these issues are worked out, there's a great deal, or at least a substantial amount of risk for any business owner, new business owner, in creating one of these hybrid entity types, right? So beware. As lawyers, your role is to make sure that you advise your clients and let them know about the risks involving creating these entity types, right? The legal risks, in particular, about creating these types of entities, right? As a new business owner, you want to make sure that the money you put into your company is not subject to these risks, right? You don't want to suddenly get stuck by some shareholder suing, saying you haven't done enough for the public good, right? You don't want to have a difficulty suing one of your managers for misusing corporate money if they can just say, well, I was doing that for the good of the community, right? And with that, thank you very much for coming and listening. We're at the end of our time now, but you are all welcome to reach out to me if you have any questions. I'm happy to help wherever I can. Thanks very much.